I will discuss some important aspects of the IBC. Today's topic is on key judicial decisions at NCLT and NCLAT. Actually, what is happening in NCLT and NCLAT with regard to various judicial decisions from time to time, we have to understand. To improve our role, to improve our assignments to a large extent. Whatever the mistakes that are committed by the resolution professionals or the financial creditors or the operational creditors or the class of creditors, through judicial pronouncements only, it will come out. And thereby, we should not and not repeat that type of errors or mistake while handling the assignments. For that purpose only, not only the Honorable Supreme Court of India judgments, but also at a lower level, at the admission level, at the appellate authority level, whatever the key judicial decisions are there, that is very, very important. Today, what I will discuss is some of the important judicial pronouncements and what area, the important area they have covered in that particular judgment. I will discuss in detail up to 5:30. And as usual, 4 o'clock, we will break for a tea for 10 minutes. And thereafter, I will continue up to 5:30. So, this is today's topic is on judicial decisions, the key judicial decisions of NCLT or NCLT. First of all, we show all the best for 2026-27 financial year in the professional front. And before going into the subject, number of literature is available with regard to judicial decisions. Quarterly journal that is published by IBBI, that is one of the important the journal. In the journal also, 1.5 page or 2 pages, they will allocate the important judicial decisions with regard to the NCLT or NCLAT or High Court or Honorable Supreme Court of India. Go through that one. And whenever you are handling the cases, the same type of the situation arises, then it is very easy to handle that type of cases also. Not only that one, the ICSI, IIP, the learning curves are there. The learning curves are also one of the important one. And only half page, if you take that full page of the particular learning curve, half page is the matter, remaining is the heading and all these things are logo, all these things are there. Have a look. Whether it is a new one or old one, there is no problem. Not only that one, the ICSI, IIP or other IPS, they are also publishing journals. Either it may be the monthly journal or the quarterly journal or special journals. If you go through that journal, definitely some good information is available by way of articles. By way of articles. Actually, today, while I preparing the next day's PowerPoint presentation, one section I have given to ICSI IIP. the base resolution plan. How many people are aware of how to prepare the base resolution plan? Because for PPIRP, the base resolution plan is very, very important. In the coming days, on account of geopolitical disturbances that are happening in the Iran or Israel versus the America, lot of problems are there for MSM. In the coming days, definitely the government of India or the banks will encourage the PPIRP, pre-packed insolvency resolution process, particularly for MSMEs. So, but okay, if at all they allowed, how to prepare the base resolution plan? How many people are aware? While preparing the base resolution plan, it is as good as a restructuring plan. The restructuring of the loan, whatever the loan obtained by the company from the financial creditor by way of a term loan or working capital or the suppliers, whatever the loans are there, the liabilities are there, how to restructure. And for restructuring, the cash flows are required. The working capital statements are to be prepared. The funds flow statements are to be prepared. And what are the cost of operations? What is the surplus generated? This surplus generated, how to use for repayment of term loan? All these things, then you have to prepare the base resolution plan. And the plan is to be approved by the financial creditors. Once the financial creditor approves, then only the process will start, the PPIR. Till such a time, you are facilitating or you are providing the consultancy services to the corporate debtor. So, before admitting the case, once you provide this type of services, definitely it is a win-win situation both to you as well as to the corporate debtors. So, like that, even for NCLT and NCLAT also, once you read the judicial pronouncement, not lengthy, I'm not asking you to download the 20 pages or 30 pages, the verdict or judgment, but in a simple manner in journals or the particularly quarterly journal or monthly journals and the ICSI, the learning point, the learning the papers, but all these things, if you go through, definitely some good results will happen. The resolution professional must continuously update their knowledge through recent judicial pronouncements. You have to update the knowledge. For that purpose, only the CAP hours are also there. Pronouncement from NCLT or NCLAT to ensure high quality. Whatever the CIRP you are going to handle, it should be the high quality. Then only the financial creditors, they will like and they will give additional cases also. Take for example, being a banker, earlier I used to handle number of cases. In the number of cases, some legal professionals, they are quickly dispose of the cases and always the benefit to the bank. Definitely we will give number of cases more to that legal advisors or advocates and those who are not giving good results to the financial institution, then we will reduce the cases also. So that's why once you are handling the case within a short span of time without legal hurdles and to satisfy all the stakeholders, including the financial creditors, definitely the financial creditors will like you and they will give the additional cases. Complaint. Once you study the NCLT or NCLAT cases, definitely the complaints will minimize. Why? Because in some cases, the verdict will be different on account of mistakes committed by the resolution professional, either IRP or RP. So we should not invite complaints. To minimize the complaints in the CIRP or liquidation or voluntary liquidation or TPIRP or the personal guarantor to corporate debtor, there is a need to update the knowledge to through the judicial decisions of NCLT and NCLAT and the efficient handling of CIRP and the liquidation process. All these things are very much required to improve the quality of your assignments. For that, IBBA newsletter is it started in 2017 till date, quarterly. Beautiful journal. The link also I have provided in the IBBA website. It is available. Downloads. Go through that one. How many cases are filed? And they have given the data also, particularly yearly. How many cases? How many CIRP? How many filed by the financial creditor? How many filed by the operational creditor? Or how many filed by the home buyers? And the data analytics are also they are giving. Not only that one and a half page or 2 pages, the important judicial pronouncement like NCLT or NCLAT or High Court or Honorable Supreme Court, they will mention. That is only 1 or 2 paragraphs. A synopsis of the case they will provide. If you go through that one, definitely some good results will happen. The quality of your assignments will increase. For that, you refer that IBBA newsletter. Not only that one. This is the first page of that IBBA newsletter. Not only that one, the orders are also like this. Only 1 paragraph or at the most 1.5 paragraph. I have taken a snapshot of the only 1 and 2 paragraphs or 3 paragraphs. Then the total case, it is very easy to understand. So the time taking for 1.5 page or 2 pages is a nominal one. Not only that one, the learning curves. The learning curves of ICSI, a beautiful one. There also, whenever the learning curves or wherever that NCLT or NCLT, what is the key on which subject the judgment was given? Next, synopsis of the case or abstract of the case, and finally, what are the key areas? Only 3 paragraphs like that. Once you go through this one, definitely you can inform to others also. Whenever your colleagues are raised some queries, definitely it will match with the judicial pronouncements. This is also good journal. Now coming to one by one, we will discuss and what is the key objectives of this particular case, and accordingly we have to develop our skills. Judicial pronouncements, because we know the code, we know the regulation, we know the rules, we know the various processes or the products of IBBA, like the products of IBBA is nothing but CIRP one product, liquidation another product, voluntary liquidation another product, prepacked insolvency another product, or personal guarantor to corporate data another product. So all these products from time to time through judicial pronouncement, if you update the knowledge, then it is gives good results to you in your profession. So Vinita Agrawal and others versus Power Pack Steels Limited Private NCLAT. In this particular sections involved 7, 5, subsection 8 are the financial debt. Facts of the case. What is the facts of the case? Certain individuals advances funds to the corporate debtor with interest. Okay. When the debt is defaulted, they filed under section 7. Under section 7. application claiming amount of the financial debt. The NCLT rejected the application holding that the transaction violated the provisions of the Companies Act relating to deposits and issue whether the transaction that may be irregular under the company law can still qualify as a financial debt under the IBC. Actually, this financial data with regard to the provisions of the Companies Act they have violated. And whether that violation takes place, whether that the debt is to be taken as a financial debt under the IBC code, that 5 subsection 8 or 7 to file the case under CIRP. Decision. The NCLAT held that the existence of the financial debt must be determined independently under IBC definition. The tribunal examined dispersal journey, how the loan is, how the amount is dispersed by the particular the financial creditor, payment of interest is there or not, TDS deduction is there or not. So these elements show the time value of the money satisfied under section 5 subsection 8 of the. So the tribunal examined these 3 points. The money is disbursed or not. So once the case is going to be admitted by that particular the NCLT, they will look into these aspects. The dispersal amount is dispersed or not, and pay interest is to be paid, the time value of the money, and the once the interest is paid, TDS to be deducted. These elements show the time value of the money satisfying. Important. RP must examine the substances of the transaction, not just statutory complaints when admitting the claims. This is not only the case to be admitted at NCLT level.
हो नाही हो मी तोच विचार करते की काय करू मी दे मला.
Okay. But also, what you have to do is whenever you are admitting the claims, either financial or the operational creditor or the class of creditor within the financial creditor, secured or unsecured classification, these points are also to be into. These points are also to be looked into. Now coming to the next one is NABARD versus SREI, SREI Equipment Limited. This is also NCLAT case. Section Silvard, Resolution Plan of Distribution Statutory Trust. NABARD is also giving loans. Sometimes they are giving direct loans and refinance also. Whenever the banks are giving any loan, that will be refinanced by the NABARD. So in this case, NABARD SREI, SREI, the equipment finance one case is there. The facts of the case is NABARD provided a refinance to SREI, SREI, equipment finance. During CIRP, the administrator treated NABARD as an ordinary financial creditor. NABARD argued that refinance receivables were first assets, not the part of a debtor's estate.
Sir, in the first case,
not the part of the debtor's estate. 1 minute, sir.
Sir, in the first case, what is the relevance of this RP examination of claims in financial debt? You are talking about financial debt.
Correct.
5.8. And what is the relevance of verification of claims with that? And deposits with any company, NBFC, will form part of financial debt?
Sir, again you tell me, sir. Again you tell me, sir. I could not catch your.
You are talking about section 7 and
5 subsection 8.
And 5 section 8, which is financial debt. Financial debt.
Correct.
What is the relevance here in verification of claims and financial debt?
Correct, sir.
Actually, and one more thing. when you deposit money in the company or
Mm.
NBFC,
Mm.
it will not form, it is not a financial debt.
Mm. It is not a financial debt, correct?
How you are correlating all these things?
Sir, how I am correlating all these things means first financial debt. For financial creditor and operational creditor, segregation is required or not?
Yes.
At a RP point of view,
Yes, it is required.
required. At the same time, whether the case is filed under Section 7 or 8 and 9 at NCLT level or not, that is also required.
Section
So,
9, not 8.
Section 8, demand notice followed by 9.
Okay.
If both are Section 8 and 9, both are they will verify whether demand notice is given and 10 days that time, and if not paid, then only the under 9 they will admit for operational creditors.
Yes, sir, correct.
Okay. So here, if at all that is not a financial credit, financial creditor, it should not be admitted. As you told correctly, that it deposits, the company deposits is not comes under the financial creditor. How the NCLT admitted under Section 7?
There should be a default and there should be a debt. And that should be supported by a disbursement. There should be time value of money.
Correct, sir.
And it should be within limitation. That should be within limitation.
Limitation. Correct. If these are satisfied, definitely that is to be that is to be admitted under Section 7. But in certain cases, what is happening is they are not fulfilling these three important factors. These three important factors, even though it is not fulfilled, they are simply admitting that one. So, suppose one example I am quoting here. One operational creditor, he is supplying some stocks to the company. And later on, the company is not in a position to pay that particular the debt. And the operational creditor insisted the company to provide some security. The security of particularly the company assets are mortgaged through mortgage deed to that particular operational creditor. Once a mortgage deed is there, simply the resolution professional admitted the case under financial creditor. But once it is an operational creditor, that too supplied the raw material, even though later on he has taken some security by way of a mortgage deed, it is not to be treated as a financial creditor.
Yes, that is correct.
In that case, wrong classification is there, then definitely the appellate authority, they will reverse the CIRP, because whatever the judgment.
There is a technical issue, madam, that Wi-Fi issue.
Sir's Wi-Fi some issue is there.
Wi-Fi लाइट गया लग रहा है सर.
Got disconnected, I think.
Now the power cut is there. Now it is restored. Savings. This okay. 5 days. Sir, here, what my contention, what is my objective of that case is wrong classification should not happen. The financial creditor to be treated as a financial creditor and the operational creditor to be treated at operational. But in some cases, even the judiciary authority like NCLT also, they have not verified thoroughly the debtors. But the basic prerequisite, even though the case is admitted, and once we have taken the case, we have to study the application form as well as the order given by the NCLT, and whether the facts as per the judge, the whatever the judgment given, and or admitted order is given, whether it is satisfied the NCLT and the IBC code or not, once again we have to verify. Once again, we have to verify. Then only the this type of errors will not arise. The valuable time will also not kill. That is the purpose. Even at the particular RP level also, whenever the claims are received, you have to properly segregate it. Then only then future problems will not arise. In the earlier, I have referred one case. In that case, the total CIRP is reversed. Wrong due to wrong classification. So that should not arise. That should not arise. Now coming to the NABARD and SRI Equipment Finance Limited, the NCLT. NABARD provided a refinance to SRI equipment. So NABARD is not most of the cases NABARD is not funding the amount directly. Indirectly they are funding. That is called a refinance. In certain cases NABARD is also direct funding is also there in certain cases. In this case NABARD provided refinance on SRI Equipment Finance Limited. During a CIRP, the administrator treated NABARD as a ordinary financial creditor. NABARD argued that the refinance receivables were trust assets, not the part of the debtors assets. So actually, the financial institution are taking and they extend the loans, they will get the refinance from NABARD. But in the books of the corporate debtor, NABARD name will not be reflected. But the banks, whenever they are submitting these proposals, they will get 90% or 75% amount from the NABARD. But in this case, what was happened is particularly the administrator treated NABARD as an ordinary financial creditor. He is not a financial creditor. He is not at all a financial creditor. Decision. NCLT ruled that the amount held in the statutory refinance schemes are third-party trusts and must be segregated before distribution to other creditors. So here, whenever the refinance type of facilities are there, some disturbance is happening.
Background noise is coming, sir.
Sir.
Some background noise.
Yes, sir. Yes, sir.
Mute, unmute.
Responded.
Okay.
Now it is okay, sir?
Yes, sir.
Now okay. So, whenever you are going to talk, you can disable that mic and talk with me, sir. No problem. So, the decision, NCLT ruled that amount held under statutory finance schemes are third-party trust and must be segregated before distribution to other creditors. What was happened in this case? If you see the particular next place, importance, resolution professional must identify statutory trustees, third-party assets, and before preparing the information memoranda and the distribution of waterfall, all these things are required. Whenever you are preparing the information memoranda, in the information memoranda, you are mentioning the financial creditor amount and who is funding that amount and operational creditor and operational creditor arises on account of workers or salaries or any supplies. All these things are to be clearly mentioned. For that sake, here wrong classification should not happen. Wrong classification should, based on the recent NCLAT ruling, February 2026, refinance provided by NABARD to the financial service provider. Banks are also called financial providers. NBFCs are also called financial service provider. These financial providers, whatever the loans they are extending, to the particular, to the their corporate debtors, then they will get a refinance from the National Bank for Agriculture and Rural Development in certain cases. So here treated as a third party asset held in trust as a not the part of the debtors insolvency estate. Here what was happened, particularly this NBFC, whenever they have given some loan, the loan is funded by indirectly by the NABARD only, not directly by the NBFC. So here also the segregation, all these things are, but in the information memorandum also, these funds are contributed by National Bank for Agriculture and Rural Development, and some plus is there in a distribution of the amount. These funds are excluded from the CIRP pool, and NABARD is entitled to recover them on priority basis rather than merely as a general creditor. He is not a general creditor, but this is a government amount, that too financial amount, that too it is a trust amount. So the plus or some weightage to be given these cases. In that NCLAT case, NCLAT decision, they have mentioned like this. So here, the financial service provider extend a loan to the corporate debtor, but the funds are get the refinance from the National Bank for Agriculture and Rural Development. And the National Bank Agriculture and Rural Development directly not funded to the corporate debtor, only through the financial service provider. But in such cases, what the resolution professional mentioned, he mentioned the NABARD, funded by NABARD like that. It is not NABARD. NABARD is funded to the financial service provider. Financial service provider in turn to the corporate debtor. So here, the NCLAT also told we should not mention the NABARD as a the direct funding to the company or the corporate debtor. Only we have to mention the financial creditor who provided the funds. But in such cases, some weightage is to be given because it is a Government of India organization. That too, they have given the refinance facility like that. Say equipment, that is Section 10A. Period, continuing default. The facts of the case is, default first occurred during COVID suspension period. So Section 10A was introduced during pandemic COVID-19 only. Because during that period, whatever the defaults are there, they should not, the financial creditor should not file the cases with NCLTs, because that is the problem of the across the country. This is not the problem with related to that particular company. However, the account remain unpaid even after 10A period ended. So they have given a 1 year period. Even after 1 year also, the particular company not paid. So in this case, the ruling was given by NCLAT. NCLAT clarified, if default continues beyond suspension period, creditors can file Section 7 application based on the later continuing default. So only if the 1 year time has given, because most of the companies are suffered the liquidity problem and other things during the pandemic COVID-19. The practical takeaway is Section 10 is not a permanent waiver of the debt. It only bars filing during that specified period. During that specified period, it is not permanent. Some of the people, they are thinking that 10A means during that pandemic that problem arose and the financial creditor should not file the case with the NCLT permanently. That is a wrong notion. So in this case, the NCLAT also clarified that a default continues beyond the suspension period, that 1 year is given. Creditors, the financial creditors, can file that Section 7 application based on later continuing default. But practical takeaway is Section 10A is not a permanent waiver of debt. It only bars the filing during the specified period only.
वॉइस भेजा ना, एक्सेल फाइल भेजी हुई। हाँ, बैंक
Next one is
लास्ट वीक भेजा था, फ्राइडे को या देखो।
next Mrudal Balwant Kulakarni versus Kakubanu Lakshmi issue.
स्टार्ट करें तो फिर क्या करें?
Hello, voice is not audible, sir. Anybody is talking, sir? Okay. So, status of home buyers and speculative investors. In home buyers, also two categories are there. One is to acquire the home or to get one flat in that particular gated community like that. Some of the people, they are purchasing the flats for speculative purpose. So they will wait for some time, they will escalate the price and they will resell that flats. These two types are there. The facts of the case is, corporate debtor argued that certain allottees were speculative investors and not genuine home buyers. So corporate debtor also in the COC meeting, he clearly told, or he appraised the matter with NCLT also, that all home buyers are not real home buyers. Some of the home buyers are speculative investors. They will purchase the flats with a lower rate and later on, due to the demand increase or the price increase, they will resell their flats to the others. These are called speculative investors and not genuine home buyers. Okay. Decision of NCLAT. The classification depends upon nature of agreement between the particular the real estate company and the home buyer. Purpose of a transaction. Entering into settlement or consent terms does not change the original character of the debt. Original character of the debt helps RP to determine voting share on the creditors classification, the real estate CIR. Suppose if at all they are not a genuine home buyers, sir, don't give any voting rights to them because they are a speculative nature means here the NCLT clearly told first take the agreement between the real estate person and the home buyer. Once I have given voting rights for the other person, even though he is having the speculative nature or not, that is immaterial. That is immaterial. The agreement is the base. So the NCLT held that classification depends upon the nature of agreement and the purpose of transaction. Entering into settlement or consent terms does not change the original character of the debt. Importance helps RP to determine the voting share and the Kratos classification in real estate CIR. So once you come across this type of situation, the agreement is the base.
Sir,
Whether he is
which
speculating.
agreement is here referred? Is it builder bar agreement or apartment bar agreement or any other agreement?
No, madam. Builder versus the buyer.
Builder bar agreement. Okay.
Yes, madam. Yes, madam. Only that agreement you have to go through. Because to reduce the voting right,
Sir,
sir.
how could I guess the speculative investor? How could I
Sir,
ascertain?
sir?
How could I ascertain who is the speculative investor, original buyers? How could I ascertain?
Ascertain. How to ascertain? Correct, sir? Sir.
Yes.
Sir, for particularly when I purchased the flat in the gated community, the agreement is a standard agreement.
Okay.
So, standard agreement for all the people, standard agreement.
Okay.
So, whether a home buyer agreement and this speculative nature buyers also agreement is one and the same or not, you can compare, and once both are same, then he may be the speculative buyer. That is a different one. So here the corporate debtor argument is no, sir, he is a speculative buyer, the buyer. So he is not a real home buyer, sir. That's why his voting right to be disabled. No. But what is the agreement between this speculative buyer and a normal home buyer? Both are one and the same. In that case, there is no change. Even though he is a speculative buyer, that is immaterial. Are you getting my point, sir?
Yes, sir.
Sir.
But in such cases, don't you think the number of units that are proposed to be bought by the person should also be criteria whether he or she is a joint home buyer?
Madam, if at all I am a wealthy person, I can buy 3 flats, no problem.
Because I remember in one of the cases.
Because I have purchased 3 flats. One is my son, one is my daughter, and one is for me. It doesn't mean.
I remember. I cannot recall the name of the case, but there was a case where a home buyer, or an authority filed an application to NCLT when the claim was delayed, and he wanted that to be condone the delay and get the debt approved. In that case, I think NCLT only passed a matter. He says because you have, the application was made for 7 or 8 units, so that means the nature of the transaction was commercial relation. They did not allow the condone of the delay, and then they said you were not a genuine home buyer, so your delay of filing a claim will not be condoned. This was in one of the cases in NCLT Delhi, I guess, where they said this shows it was a commercial investment by you, so we will not condone your deal for the purpose of condoning a delay. I'm not saying about the Section 7 application or RP. For condoning delay, this was the view taken by the NCLT in one of the cases.
Correct. Madam, here at your level, that is resolution or interim resolution professional level, mostly IRP level only. So when you are admitting the case as a financial creditor, that too under home buyers under financial creditor category, you see the agreement. And once the agreement is tallied with all the other agreement, you admit. Later on, if at all any dispute is there, that is not at your level, that is adjudicating authority level only. He will decide. Equitas, a small finance bank, and Jimbo Finvest. Whether the financial service provider is subject to CIR. Actually, here the financial criteria is not comes under the purview of the CAR. He may borrow some amount from other organ. Suppose this is a small finance bank. Small finance banks are also getting fund. They are borrowing from others, and the private placement funds are also there. Once the small finance bank is defaulted that amount, who has given that amount? The private placement person who provided the loan to the small finance bank. If at all bank is not paid, then he is not eligible to file a case against the financial service providers. Whether financial service provider can be subject to CIRP, Section 7 was filed against NBFC or the banks. That is in this case, Equitas is a small finance bank, which under regulatory restrictions, but still registered as a financial service providers. Therefore, suppose one bank, they have taken a loan from other persons through private placement, and the bank is not paid on due date. The private placement person, he should not file the case under IBC with the NCLT under Section 7. Decision. NCLAT held that unless a license is cancelled or government notification brings such entity under IBC, it cannot be treated as a corporated. NCLAT held that unless a license is cancelled or government notification brings such entity under IBC, it cannot be treated as a corporated. So, the resolution professional must verify the corporate status before filing or advising on CIR. Expert Reality Professionals Private Limited versus Logix Infrastructure. Issue. Recall of a resolution plan on the grounds of a fraud. Facts. The allegations emerged that a successful resolution applicant was related to promoters and has suppressed the material information. Ruling. NCLAT upheld the NCLT power to recall the resolution plan approval if a fraud or collusion is discovered at any stage. At any stage. That's why we have to verify thoroughly the Section 29A, whether he is a related party or not, whether he is a willful defaulter or not. Whatever the conditions that are mentioned under Section 29A to be thoroughly verified by the resolution professional only. And in this case, he is a related party. That's why at any moment, even though resolution plan is approved by the NCLT, Honorable NCLT, then it can be reversed also. Practical implication, even after the plan approval, RP must ensure full disclosure, strict compliance with the Section 29A. That is very much required. If that is 29A is casual approach is there, this type of problems will arise. The consequences also there. Once I have not verified properly the credentials of the prospective resolution applicant, then NCLT directly write a letter to the IBBA disciplinary committee that Mr. Prasad has did like this. Then IBBA will send one letter to me. Why you are negligent on account of 29A? Why not take an action or penalty against you? Your answer should, your reply should be within so and so. So, whatever this type of negligence on the part of the RPs are there, or IRPs are there, or liquidators are there, directly the NCLT sends that information to the particular IBBA. IBBA disciplinary committee they will shoot a letter to the concerned IRP or RP or liquidator, and they called the explanation. Based on the explanation, they will take a call and they will face to face online also. They will ask the questions, and accordingly you have to answer. Then only they will give the judgment, the penalty or the suspension or the cancellation of depending upon the severity of that particular degree of that particular error, they will cancel the certificate of practice also. Future Corporate Resources Private Limited. Demat account freezing case, NCLAT. Facts. Stock exchange froze the demat accounts of the company undergoing CIR due to non-payment of a listing of fees. Yes. RP sought defreezing to deal with the shares during the resolution. Here, listing agreement, listing LODR, listing obligation disclosure requirement, one regulation is there, that is a Securities Exchange Board of India. So you have to go through that one, LODR. So in the LODR also, whenever the company shares are listed either in NSE or BSE, during CIRP also, we have to fulfill the listing obligations. Whatever the fees, whatever the continuation is required, Otherwise, they will impose the penalty. For that, we have to pay from our pocket. If a penalty is there, not a timely address. So, once you are handling a case, whether it is a listed company or unlisted company, if at all listed company is there, we have to fulfill. But in this case, what has happened? Due to non-payment of a listing fees, they froze the demat account, which is not correct. RP sought defreezing to deal with the shares during resolution. Decision. NCLAT dismissed the exchange appeal and upheld NCLT's authority to order defreezing, confirming that insolvency tribunals have jurisdiction over securities to preserve value. So they don't have the right. Okay, we have to pay the fees. If at all still even during CIRP also, if the shares are listing in the stock exchanges, we have to pay the amount. But they should not defreeze the demat accounts of the company under CIRP. So this is the case with regard to Future Corporate Resources Private Limited versus demat account of a freezing case. Importance. Important for RP dealing with listed companies and pledged shares. So whenever the company is pledging shares, company shares for getting or availing any loan, this type of situations will arise. Please be cautious. Alchemist Limited CIRP recall case. Facts. The Enforcement Directorate informed the tribunal that insolvency process has been initiated through collusive transactions and money laundering. Underline. So the Enforcement Directorate informed to the NCLT, that is tribunal, that the insolvency process has been initiated through collusive transactions, money laundering. Immediately, the decision of NCLT recalled the CIR order, holding that insolvency proceedings initiated through fraud cannot be allowed to continue. Suppose here, once the Enforcement Directorate given the full information to the tribunal that collusive transactions and money laundering is there, that's why they have initiated the CIRP. Stop that one means with full proof. If they have given the NCLT, even though IBC prevailed over other acts, in these circumstances, that definitely they will reverse the CIRP by the tribunals. Importance. IBC process is vulnerable to misuse. Tribunals now exercise stricter scrutiny at admission stage. So some of the cases at admission, some problems are there, some problems. So we have to verify that one properly. Then only this type of the problems will not arise. So in this case, the NCLT did a small mistake, and they have not in detail, because number of cases are there. Sometimes this type of errors are arise. So that's why the enforcement directly wrote a letter to the adjudicating authority about that particular company, how they misappropriated, how they did the money laundering. Then they reversed based on the facts of the case. Unsold properties and infrastructure. And in this case, during insolvency of a real estate company, the development authority complained that the rights over the land were ignored in CAR. During insolvency of a real estate company, the development authority complained that the rights over land are ignored in CAR. What was happened? NCLT held that statutory authorities or public bodies must be heard before major decisions that affecting land and planning approvals are taken on. Planning. So here, the resolution professional must involve development authorities, municipal bodies, especially in the real estate insolvency also. So whatever the complaints, even though IBC prevailed over the other acts, but here, once in this case, what was happened? The real estate company, development authority complained, rights over the land were ignored in CAR. That is to be properly addressed. That is to be properly addressed while during that CARP process. NCLT held that statutory authorities and public bodies must heard. You have to listen. If RERA arguments are there, that's why in most of the real estate the projects, the committee of creditors, the regulator also we are taking. We are taking the regulator also. The RERA people, they will also participate. There is no voting right because they are experts. They are experts in the line of activity, and we may not aware. And based on their observations also, the final call will be taken by COC as well as the adjudicating authority. So whenever you are handling, or especially the real estate projects under CARP, take the services of the person, write a letter to the RERA of the particular state. They will depute one official for COC meetings, but he don't have any voting rights, but he can participate because this is a technical subject, and COC may not aware, or the RP may not aware, and he may be aware of the regulations thoroughly, and that information gives us some insights about what are the transactions, bad transactions, or irregular transactions that were committed by the corporate data. So that for that, we have to take up the matter with the concerned NCLT. Whatever his observations, we have to follow. So in this case, clearly the NCLAT told clearly, statutory authorities and public bodies must be heard before major decisions affecting the land or planning approvals are taken. Not simply, no, IBC prevail over other acts. I don't listen means that is not correct. So that importance is the resolution professions must involve development authorities or the municipal bodies, especially in the real estate insolvency. IL&FS energy development, government stake acquisition. Sometimes the governments are also interested to take some share through the resolution plans. In this case, what was happened? Rajasthan government proposed acquisition of a stake in a renewable energy joint venture during a IL&FS group resolution. So today, the resolution plans are, group resolution plans are also to be, if at all it is viable, if at all it is feasible, then we have to accept as a prospective resolution applicant, and accordingly we have to give the weightage in the particular evaluation matrix. Always don't think about only single the resolution, prospective resolution applicant. Today, to get the full amount in one go, some of the 2 or 3 people, they will file the case, they will file the resolution plan. So we have to give special attention to those cases also. Because in Hyderabad also, I have seen in a real estate project also, 2 people are submitted combinedly the resolution plan. Okay. Whether they are going to acquire 2 or 3, that is immaterial for me, because maximization is my main motto. Fulfilling the IBC rules or regulation. There is no bar in regulation that more than 1% should not be they filed by the for this resolution plans like that. There is no such conditions are there. So in this case also, the Rajasthan government proposed acquisition stake in a renewable energy joint venture during ILFC group resolution. Joint venture decision. NCLT approved the transaction. Observing that value maximization and public interest justified deviation from ordinary asset sale procedures. Important, show flexibility of the insolvency tribunal in complex group resolutions. In the group resolutions, you have to give special attention. Why this group? Once this resolution plan is approved, what are the benefits to the stakeholders of the CAR? Once it is satisfied, value maximization is satisfied, and the stakeholders are they get a benefit, there is no problem. Whether it is a group resolution or individual resolution, that no matter. So in this case, the Rajasthan government immediately NCLT, they have not accepted. Then they approached the NCLT. NCLT approved the transaction. Observing that value maximization. Once the government is taken full amount in one go, and public interest and justified deviation from ordinary asset sale procedures, shows a flexibility in the insolvency tribunals in the complex group resolution. Next, if you go through these decided cases, defreezing security, one area. So we have to follow the particular the listing agreement conditions. We should not allow the stock exchanges to freeze the demat accounts of the company shares, recall CIRP resolution, and whatever related party is there. Later on it was found there is a full authority for the NCLT to recall that particular resolution if at all any fraudulent transaction later on discovered, and the protection to the public authority rights. The protection is also, particularly if any development authority with regard to real estate, that is also to be addressed properly. Increase focus on fraud prevention. If we see the alchemist the fraud prevention, we have to minimize 29A. We have to thoroughly examine logics, the infrastructure case also. Clarification of the creditors classification, home buyers versus investors, the speculative investors also, you have to verify once again, then take a call. Financial debt and with the deposits, the company deposits are different. The financial debt, whether it is comes under the this one or not, you thoroughly examine before correct classification. Correct classification. Whether the NCLT at the time of admission of the case or as a IRP or RP, while your claims are admitted or not to be admitted, thoroughly examine the each and every cases, then the quality of the CIRP will increase. And personal guarantor jurisdiction, insolvency cannot be used to steal surfacing. Some other people during surfacing to stop the sale of the asset, personal guarantors are filed the case under PG2CD. Proper invocation of guarantee remains critical. All these things in the coming, this one also I will discuss. Tribunal scrutiny of the resolution plans. Fraudulent and related parties are to be recalled. COC cannot modify the plan after the approval of the plan. Procedural discipline becomes stricter. Delay condonation become rare, and late claims being rejected more frequently. All these things in the coming cases I will discuss. Some more judicial precedents of NCLT or NCLAT with description. With the description. And IBBA also, they have issued one circular. What are the mistakes that are committed by the resolution professions while handling the cases of CIRP or liquidation or voluntary liquidation, etc. And please go through that circulars also from time to time. Once you go through that one, definitely the same mistakes are not repeated in your assignments. Thereby the quality will also increase. Now coming to Chikali Nagaraju Ispat Corporation Limited, the NCLAT case. Facts. The financial creditor filed under Section 7, but a default date initially fell within COVID-19. Section 10A suspension period. Later, the creditor sought amendment to show the earlier default date. Ruling. NCLT allowed amendment since the document evidence proved default occurred prior to the Section 10A period. Key. Amendment default date is permissible to prevent genuineness cases from being rejected on technical grounds. The 10A, whatever the 10A period is there, this is during pandemic period, that to 1 year the cases are to be deferred. So whether the default is arise during that period or not, thorough verification is required. If at all during that period, the case should not be admitted. And sometimes if the prior default is there, then that is to be brought to the notice of the NCLT also. Here we have to read the Section 10A thoroughly. Section 10A of the Insolvency and Bankruptcy Code, introduced in June 2020, suspend the initiation of a CIRP for defaults arising between March 25, 2020 to March 24, 2021. It provides permanent shield against the insolvency filings for COVID-19 related debts, protecting the companies from bankruptcy proceedings for defaults occurring during this period. So the default date is also very, very important. So in the banks also, the default date. The default date, how to arrive? The classification of asset. The classification of asset, how they will classify: standard asset, substandard asset, doubtful, 1 year, doubtful up to 3 years, over 3 years, and loss assets. This is a classification of their loans, bank loans. Bank loans is nothing but assets of the bank. So, whenever the borrower is not paid on due date, suppose the repayment is there, term loans, the repayment, they will give 90 days time to repay the loan from the due date, where the due date is available. If you see the terms and conditions of the loan sanctioned by the bank, whenever the banks are sanctioning any loan, they will take one agreement that is called sanction terms and conditions. Sanction terms and condition. In the sanction terms and condition, repayment schedule is also there. In the repayment schedule, you see the repayment schedule, whether the amount is paid on that particular day or not. Once it is not there, that is called as a default date. Once it is not paid, the bankers are also send a notice also. That is also to be treated as a demand notice. Like section 8 and 9, demand notice followed by filing, that is not applicable in case of financial creditors. Once the loan is defaulted and satisfied by the NCLT, that is adjudicating authority, straight away he can admit the case. But in case of operational creditor, the demand notice sent or not, and whether any dispute about that particular product, by quality wise, price wise, delay in providing all these things are there, then the case should not be admitted. Otherwise, the case. That's why today, whenever the operational creditors are filing the case, the NCLT is also taking a declaration or affidavit, then there is no dispute in this case. NCLTs are not to resolve the disputes of the operational creditor. It is to resolution of the debt, not a dispute resolution process. So that's why the 10A or the 10A here, 10A, the period is also to be taken into consideration. Jamir Pavan Kumar Agrawal versus Pankaj Goenka. Personal guarantor filed insolvency application claiming limitation were extended due to one-time settlement proposal. Personal guarantor filed insolvency application claiming limitation was extended due to one-time settlement proposal. NCLT held that OTS proposal is not an acknowledgement of debt under Section 18 of the Limitation Act. The Limitation Act, the limitation for guarantor insurance begins from the demand notice of the or the recovery notice in case of debt, not the OTS discussion. So here, the personal guarantor filed the insolvency application claiming that a limitation extended due to one-time settlement proposal. Here, the limitation period starts in case of a personal guarantor is the invocation of the guarantee. The invocation of guarantee, that too through demand notice. Once the demand notice is served by the financial creditor to the guarantor, then if the guarantor not paid the amount, then he is obligated to pay that amount. But in case of the recovery certificate, normally when the cases are filed by the banks with debt recovery tribunals, DRTs after finalization of that particular one, they will give the recovery certificate to the financial creditors. So demand notice or recovery notice is the base, not the one-time settlement. So here, for all of these things, being a resolution professionals, we should know about the importance of Section 18 and Section 19. Section 18 and then Section 19. What is a Section 18? Acknowledgement of debt. What is meant by Section 19? Part payment of the debt. Part payment of the debt. Suppose I have taken a loan. I have given a demand promissory note. Demand promissory note to the bank. After 3 years, the note is invalid because the period of limitation is crossed. Banks has to file the case before 3 years only. Before 3 years only. So, before 3 years, one day before, or the date of the expiry of the 3 days, if the bank taken one acknowledgement, so I have taken a loan and I promise to pay so and so date like that, then that fresh limitation period started from the date of acknowledgement. That is defined under Section 18. But whereas Section 19, what is a Section 19? Suppose before 3 years, if at all borrower, that is corporate debtor, paid some amount, then from that date to 3 years, it will extend. That is called part payment of debt. Part payment of debt. But in some of the cases, the NCLT also rejected the cases are not admitted, even though financial creditors submitted the applications and all these things. It is a time-barred document. Time-barred document means banks are to be show the acknowledgement of debt. But the Honorable Supreme Court of India recently given one judgment. Even if the corporate debtor mentioned the liability of the loan in their balance sheet, the balance sheet is also deemed to be treated as an acknowledgement of debt. There is no separate signature of acknowledgement is not required. Not required. So, Section 18 of the Limitation Act 1963 provides that if a written signed acknowledgement of liability regarding the property or right is made before the original limitation period expires, a fresh period of limitation starts from the date of acknowledgement. It is essentially extended the deadline for the legal action often used in the debt recovery. In the debt recovery. Any doubts on this aspect, sir, madam? Limitation Act or the default date. Any doubts and clarifications? Sir or madam? Am I audible, sir?
Yes, sir.
Yes, sir. Audible, sir.
Okay, sir. Any doubts? Okay. Asset Reconstruction Company India Limited versus Vishal Jaiswal and another. The Supreme Court of India has firmly established that acknowledgement of debt in a company audited balance sheet constitutes a valid acknowledgement of liability under Section 18 of the Limitation Act, 1960. So, in that particular case, the Honorable Supreme Court of India clearly told, okay, documents are there. Documents are executed 10 years back. After 3 years, the documents are expired. So, the documents are not valid as per the Limitation Act. Latest balance sheet, the company mentioned the liability of the bank loan in their balance sheet. That is also to be treated as acknowledgement of debt. So from the date of that particular balance sheet, fresh the limitation period will start. The Supreme Court of India formally established that acknowledgement of debt in company's audit balance sheet constitute a valid acknowledgement liability under Section 18 of the Limitation Act, which consequently extend the limitation period under IBC. This means that even the debt is more than 3 years old, a recent balance sheet entry confirming that liability can make the debt legally enforceable for an IBC petition. For an IBC petition. Again,
Question, sir.
sir.
In section 19, you say that the partial payments of debts can continue the limitation period. Is
Correct,
there
sir.
any
Correct,
amount, percentage of what is the partial payment? Is there any amount or any amount?
No. Sir, even 1 rupee also. That's why the bankers, our practice is also, whenever the loan is, the document, revival letter is not signed by the borrower, the acknowledgement of debt, borrower is reluctant to pay, the sign on the particular document. Then we will ask, you pay 100 rupees. So we will give the receipt and he will fill up 100 rupees and that is to be treated as a part payment of debt from the date to 3 years it will cut.
3 years. Okay, sir.
But borrower signature on the receipt is compulsory, sir.
Compulsory, sir. Compulsory.
That is
not by the third party.
Some banks are paying on their own 100 rupees. But it is not allowed.
Not allowed. Correct, sir. Correct. Next, Equitas, a small finance bank, Jimbo Finance. Facts. Section 7 application filed against the financial service provider whose license had not been cancelled. Financial service providers are excluded from IBC unless notified by the government. And the key takeaway, banks and NBFCs cannot drag it into CIR unless specifically government any order is given, then only they will come into the fold. Banks are also borrowing, even small finance banks, RRBs also, whenever the liquidity problem arises, they will borrow. For that earlier, FRDA bill is there. FRDA. Actually, it was 2016, the IBC bill. And in 2017, the FRDA bill also initiated by the government of India. In most of the countries, the two acts are there, FRDA bill, IBC. It is the two eyes of the government. One is non-financial institution. Second one is financial institution. So at that time also, if you go through that, remember the FRDA bill, those who completed the IBC, they can handle the financial institution. If any cooperative bank or chit fund or non-banking financial companies not paid the amount and the insolvency process to be handled by the So the bill was introduced in Government of India for resolution of the financial institution similar to IBC for companies is a financial resolution and a deposit insurance bill, FRDI bill, financial resolution and deposit insurance 2017. Introduced in Lok Sabha 2000 August, aimed to create the framework for resolving stress in banks, insurance companies, even insurance companies also. Once insurance policy is taken, but insurance company not paid the claim, then the claimant can file an application with NCLT or the NCLT. So that, but later it was withdrawn due to controversies, particularly at that time, bail-in clause, the people are, but in most of the developed countries, the both FRDA bill, IBC bill is the FRDA and IBC is also there. Now,
Sir, sorry, sir,
NCLT
one
demand-
question. Sir,
tell me, sir. Sir,
whether the regulator can file this application,
no,
for example, the RBI or the IRDA, or
no,
the
no,
insurance
no, sir,
regulator,
no, sir. No, sir, no, sir.
not there, huh? Okay.
But
Financial service
but
provider.
any regulator, the Jews are not satisfied. They can file, they can submit their dues to the resolution professions.
Regulator
Can you
can
come
also
again, sir? I didn't get.
Sir?
Regulator
Can-
can also submit to RP.
The claims, particularly earlier, Securities Exchange Board of India is there. It is a regulator for capital market. It is a regulator for capital market. So the listing LODR requirements, listing obligation disclosure requirement, if at all any dues are to be paid by the corporate debtor to the SEBI, then SEBI can file their claim to the RP. RP has to admit that.
Sir, any financial service provider is notified till now.
Financial service provider? No, sir. So far, zero.
Oh.
So far, zero.
Any NBFC?
No, so far, zero, sir.
Okay.
Sir, once this FRDA at that time, 2016, after IBC, everybody is happy. Even chit funds, if at all defaulted, or insurance claims, nearly 30 life insurance, 30 general insurance, if they have not paid the claims, so many NBFCs, the NBFCs are nearly 20 to 30,000 NBFCs are there. Different NBFCs are there. So if they are defaulted, there comes under the purview of the FRDA bill. So everybody is happy because the professional, the opportunities are more, both IBC as well as FRDA. But people are rejected the FRDA bill. The government withdrawn the FRDA. So far, to my knowledge is concerned, no financial service provider included by the government under GO, not at zero, sir. Nobody has admitted under IBC. Okay.
Apply for Section 7, but they can be treated as the resolution applicant.
Sir, tell me, sir.
They can't apply under Section 7, any financial service providers, but they can become the resolution applicant.
They can file their claims, sir. Suppose take for example, sir. Take for example, bank is filing means they can file, na? Bank can file, but a bank, any person is given loan or a deposit. Suppose you have deposited your fund with the bank, sir. Take for example 1 crore. Bank is that is a demand deposit. You have approached the bank. That is savings bank. That is called demand deposit. Bank told liquidity problem is there. I'm deferring. You will please come after 1 month or 2 months like that. Then you can file a case against the bank under FRDA bill. The FRDA bill is not there. But if at all anybody taken a loan from the bank, they can file an application with NCLT under IBC. But bank is defaulted. Nobody, as on date, nobody is they eligible to file the case against the bank.
Sir, then the option is to go to only ombudsman, sir.
Sir, ombudsman is
that is anyway outside IBC. Yeah.
That is a deficiency of service. Deficiency of service. Suppose take for example interest difference and all these things are there, are they rejected? Deficiency of service. Suppose if at all any financial institution is defaulted means first comes in DACGC, Deposit Insurance and Credit Guarantee Corporation. DACGC. Up to 5 lakhs they will pay. Remaining lakhs, 5 lakhs. Thereafter,
Hmm.
the banks, the Reserve Bank of India will appoint the insolvency and other process, whether it will be merged with other bank or whatever the assets are there, they will recover all these things. For that purpose only, the FRDA bill is introduced today. But people are rejected that one. Public is rejected that one. Now,
Thank you.
coming to, sir. Sir, shall we take a break for 10 minutes?
Okay, sir.
Okay, sir.
Okay, sir.
Okay.
Okay, sir. Set. Now, the next one is NCLAT demat defracing case. Already we have discussed about this case in another area, another case, future corporate resources. Stock exchange froze the demat accounts due to non-payment of listing fees. RP requested NCLT to defreeze sell the shares for resolution. Ruling. NCLT upheld NCLT's jurisdiction under section 60 subsection 5 of the ordering defreeze. RP has the authority to deal with the securities and financial assets of the maximization of the value. So here, whenever the listed companies are there, so if at all any company, their shares are pledged, then definitely the freezing of the shares will be done by the concerned the stock exchanges, and you have to inform to the NCLT or the adjudicating authority to defreeze that fund. And definitely they will do the defreezing process based on the NCLT's order. Section 60 subsection 5. What is the 60 subsection 5? Of IBC grants, NCLT brought overriding the jurisdiction to entertain any application, proceeding, or a dispute, including questions of law or fact arising out of in relation to the insolvency or liquidation of the corporator. Overriding power. The NCLT can decide matters despite anything contrary to the other laws. That is section 60 subsection 5. Blue Smart Mobility Insolvency Admission, NCLT Ahmedabad. Electric cab start-up defaulted 1.28 crores to Catalyst Trusteeship. Ruling. Tribunal admitted CIRP at an appointed IRP despite company being a venture-backed by stock. Whether it is a venture-backed or startup company, whatever it is there, that is immaterial. So the venture capital through venture capital fund always risk oriented. So if at all the companies are using venture capital, success or failure may also be there. The venture capital normally be used for the research and development, particularly pharma companies. They are using the venture funds from the various trustees funded. So the key takeaway is particularly startup and tech companies are equally subjected to IBC once a default threshold is met. So no, sir, that this is a venture capital, sir. The success and the failures are always be there. That is no question. Once a default is there, default is satisfied by the NCLT, definitely the case is to be admitted. So here, even the electric cab startup, particularly electric cabs, that is startup companies are increasing and they have defaulted 1.28. The consideration, the soft corner is not there. Once defaulted means defaulted. Defaulted, if a threshold limit is crossed, then it is to be admitted. Recall notice during the particular section 10 period, NCLT clarification. Creditors issued a recall notice during COVID-19 suspension period. Ruling. Recall notices does not create a fresh default. It only confirms the earlier default. Takeaway. Prevents a creditor from artificially creating default post 10A to revive the barred claims. Some of the people, they are tactfully handling. So again, the recall notice, once the recall notice is given, that is not the fresh default. Earlier default is the base. Suppose I take for example, in this case, before COVID, if at all any demand notice issued by the bank to repay the loan, that date is a final date, the default date, not the subsequent notice date. So some companies, they are using this tactics to to drag on the case for another year like that. 10A. Section 10A of the IBC, introduced in June 2020, suspend the initiation of CIRP. The period also earlier also I have mentioned. It provide a permanent shield against the insolvency filing of COVID-19 related to debts, protecting the company from the bankruptcy proceedings or for defaults occurring this period. Okay. Personal guarantor limitation from recovery certificate. Bank obtained a DRT recovery certificate and later initiated insolvency against the guarantor. Ruling. Limitation begins from the recovery certificate issuance. Takeaway. Recovery proceedings and IBC timelines are interlinked for guarantors. Recovery proceedings and IBC timelines are interlinked for guarantors. So here, even a recovery certificate is also deemed to be treated as a demand notice. Demand notice. The term personal guarantor limitation starts from recovery certificate, refers to the 3-year legal time limit within the financial creditor must initiate insolvency proceedings against the personal guarantor after recovery certificate has been issued by the debt recovery tribunal. Next, operational creditor the petition after full settlement. Some of the people, fictitious applications are also filed with the NCLTs and the NCLT in this case decision is given. Operational creditor filed Section 9 despite receiving full and final settlement. Ruling. Petition dismissed as abuse process. Key takeaway. IBC cannot be used pressure tactics after settlement. So here, in case where the settlement is reached after operational creditor petition is filed, the resolution professional still maintain mandatory duty to receive, collate, and verify all the claims are submitted by the creditors during the CIRP. If the settlement is proposed, it must typically be approved by the adjudicating authority, often through Section 12A application with 90% COC that is required. So some of the operational creditor settlement is completed and full payment was made, and if at all he is going to withdraw, that is not possible, and whatever the process is there, that is to be completed by the resolution profession. In this case also, the Section 12A application with 90% COC voting share is also required. So once the case is admitted before formation of a COC, then it is possible. After formation of COC, it is not possible. Service of notice through MCA.
But sir, in newly amendment act, there is the letter of options. Only after can be done only after the formation of COC. In newly amendment.
That is an amendment. You are talking
new
about
amendment. Yeah.
Okay. Correct.
It has limited, sir. It has limited the window actually for.
Correct.
But it is still not effective, no, sir. Not yet notified.
Not yet notified him. No, the GO
rules
is also
and regulations.
Regulations are to be released, sir.
Yeah.
Once the act is there for operational area, regulations are important. Then IBBI has to issue the revised regulations. Next, sir.
I think the main aim is to prevent misuse of this 12A, no, sir. Section 12, to prevent the misuse of this Section 12A. The amendment has happened.
Correct. Sir, service notice through MCA registered email. NCLAT 2025. Corporate debtor argued that a demand notice was not properly served. Ruling. Email sent to MCA registered address constitute valid service. So whatever the ROC website is there, in the ROC website, whatever the official communication email is there, if that is used, then corporate data cannot evade the proceedings by ignoring the official email. Under the Insolvency and Bankruptcy Code, sending a demand notice via email is a legally valid method of service, provided it adheres to the specific procedural requirement. The NCLAT and NCLT benches have consistently held that service on a registered email address is sufficient to satisfy the Section 8 of the code. So here the demand notice, particularly operational creditor, first they will issue the demand notice, Section 8, followed by Section 9, filing of application. Government the acquisition, particularly this I have already discussed this one. And transferred winding up petitions must be met IBC threshold. NCLAT, latest case. Old company petitions transferred from High Court to debt below 1 crore threshold. Actually here, earlier, if you see the earlier, the threshold limit for initiating insolvency proceedings under IBC, 1 lakh to 1 crore with effect from 24th March 2020. This increase was enacted by the Ministry of Corporate Affairs through a notification to prevent it triggering the insolvency against MSME during COVID-19. But actually, earlier, that is before 2020, the case was filed with the High Court. Now the case is shifted to that particular NCLT, and they are arguing that earlier the limit is 1 lakh only, then it satisfies the data. No, here the ruling is such petitions cannot continue unless they meet the current IBC threshold. So earlier the High Court sir that earlier 80 lakhs sir, 80 lakhs that is above 1 lakh, then that default amount satisfies means that is not correct. So the NCLAT ruling is such petitions cannot continue unless they meet the current IBC threshold. Prevent misuse of legacy proceedings to bypass IBC eligibility norms. Financial debt, commercial effect of borrowing. Investor claimed refundable advance as a financial debt. Tribunal examined whether money was disbursed against a time value of the money or not. Not every advance qualifies as a financial debt. So here, refundable advance as a financial debt, investor claim. Here, a refundable advance paid by an investor to a corporate debtor generally does not fall under the definition of financial debt under the IBC, unless transaction was specifically made against the consideration of a time value of money, such as a loan with interest. Actually, the time value of the money is today's 1 rupee is not equivalent to after 1 year 1 rupee. So for that only the interest we are paying. Interest is also for that purpose only. So if that advance is carries some rate of interest, that a time value of money is also recognized, then it is to be treated as a financial debt. Otherwise, it is not financial debt. However, such advances are often recognized under IBC as operational debt if they were paid for supply of goods or services that were not delivered. That was not delivered. So most of the cases, particularly the advance refund, if at all any is there, and not carrying any rate of interest or time value of money is not there, then that is to be treated as an operational debt, not the financial debt. Section 25 of the fraudulent initiation.
Sir,
Corporate
one
data.
question, sir. Sorry, one question, sir.
Sir, tell me, sir.
Sir, the interest-free loan, if it is there, loans without interest. I think there was some Supreme Court decision saying that is also part of financial debt. I can't recollect the Supreme Court decision.
Correct, sir. That also, sir, suppose take for example, some floods were happened. Imagine one situation. Floods were happened. Government asked the banks to provide loans to the corporates also, those who are suffered under that tsunami or floods. And don't charge any rate of interest. That rate of interest will be borne by the government of India, means that is also a financial debt. Even though the bank, the financial institution or financial service provider is not directly charging interest, but he is getting that interest from the government, that is also to be treated as a financial debt. But one thing, sir, beyond all these things, agreement we have to verify, sir. For financial debt or operational debt, normally agreements are not available. Operational debt agreements are not available. For financial debt, hypothecation agreement is there, or mortgage agreement is there. So banks are also taking some various agreements. So the agreements followed. Once you read the agreement, definitely whether it is a financial debt or operational debt, it is very easy to classify either financial or operational debt. But here also, sir, even though the zero rate of interest is there, take for example, some concessional rate, some backward states or backward districts. The banks are also giving some loans, and the interest is not charged. The interest they are getting from the government of India. So it doesn't mean that it is not a financial debt. It is a financial debt. But the financial service provider not directly charging the interest from the borrower, but indirectly they are getting from the government of India or other sources. But case by case, we have to go through the agreement, sir. Once the agreement, once you go through the agreement, whether it is a financial debt or operational debt, it is very easy for you also to identify. Classified.
Okay. Thank you, sir.
This is a clear evidence sufficient. Corporate insolvency, maliciously fraud. Sir, corporate data alleged insolvency was filed maliciously. Fraud must be proved with clear evidence. Mere allegation insufficient. Section 65 is not a routine defense against CIR. So some other people, it is fraudulently filed by the financial creditor or operational creditor, like that. Okay. Whenever such cases are there, you have to brought to the notice of the NCLT whether the fraudulent, it is fraudulently filed or not with proofs. Otherwise, some of the particular corporate debtors are argued it is a fraudulent like that. So here also the 65 says is designed to penalize any person who initiate a CIRP or liquidation proceedings fraudulently or with malicious intent for any other purpose other than the resolution. Okay. Under the IBC, 65 is not intended as a routine defense, but as a specialized safeguard to prevent the misuse of the insolvency process. Courts and tribunals have consistently ruled that this provision should only be invoked in exceptional circumstances where there is a clear evidence of a bad faith. So, once the corporate debtor is told it is a fraudulent filing, means you have to prove with evidences. Otherwise, it is deemed to be treated as it is not fraudulently filed. Replacement of liquidator in voluntary liquidation. Voluntary liquidation is entirely different. Voluntary liquidation earlier, it is there in the Companies Act. But after the framing of this IBC code, voluntary liquidation is shifted from Companies Act to the IBC code. IBC code. So, because only one part is there in Companies Act, simply they shifted it to IBC. So, CIRP, liquidation, voluntary liquidation, PPIRP, personal guarantor to corporate debtor. These are the various products released by the IBPI. But here, replacement of liquidator in voluntary liquidation. Shareholders replaced the liquidator due to dissatisfaction. Shareholders. Tribunal held that shareholders have authority in voluntary liquidation. In voluntary liquidation, where assets are matching with the liabilities, the corporate debtor itself filed the case with the certain procedure, he will file. For that also, the shareholders' consent is also required. In general meeting or extraordinary general meeting. So, voluntary liquidation is a stakeholders driven, unlike a CIRP liquidation. CIRP is different. And the CIRP followed by liquidation is different from voluntary liquidation. That's why in voluntary liquidation, the shareholders are having a right to replace the liquidator. Replacement of voluntary liquidator in voluntary liquidation. Shareholders and stakeholders have right to replace the liquidator if they are dissatisfied with the progress or transparency or fairness of the liquidation process. This is typically done due to the loss of confidence in the liquidator's ability to maximize the asset value for a dragging out of the process. Then the shareholders can replace the liquidator with a new liquidator. This is not like a CIRP followed by liquidation. This is purely voluntary liquidation. In the voluntary liquidation, the shareholders are having a right to change or replace the liquidators. Invocation of the personal guarantor through surfacing notice. Guarantor argued guarantee was not formally invoked. Today, whenever the personal guarantor to corporate debtor filed with the NCLT, the guarantors are first they will rise. Guarantee is not formally invoked. In SURFACE 2002, two important sections are there. That is a section 13 subsection 2 or 13 subsection 4. Subsection 4 of SURFACE Act 2002. Normally these bankers, they are calling 13.2 notice, 13.4 notice like that. But these are the two important sections. Section 13.2 surfacing note a demand payment amount to invocation. Bank need not send separate invocation letter if notice is a clearly demand payment. More or less, both are one and the same. Once we are giving a notice to the particularly borrower, if the loan is guaranteed by the guarantor also, parallelly we are sending and parallelly we are publishing in the newspaper also. What is the formality? We don't know. So the guarantor argued, guarantee not formally invoked. But in that situation, we have to mention about section 13 subsection 2 of the Surface Act. Notice demanding payment amount to invocation. Banks need not to send separate invocation letter. If notice is clearly demand the payment. If you see the
Sir, if you are going to file under section 95, personal guarantee case, under
Sir.
rule 7.2 notice is mandatory.
correct.
Suppose
Notice is mandatory. Correct.
But whether I can take both these measures simultaneously, banks can take.
Sir, once your efforts are fertile under Surface Act 2002, then you are moving towards the IBC, na? Both are both are not running parallelly.
Yes.
But today, what is happening in the banking also, you are also aware of that one. First, we will cost less means surfacing. Cost less. The resolution cost is very less in Surface Act 2000. Only we will issue the notices. Thereafter, we will appoint the particular recovery agency and seize the assets and sell the market and appropriate the same. Whatever the shortfall is there, we will recover from the guarantor like that. And sometimes banks, even though their surface is not efficient, and some of the people, they are approaching High Court and that one, this one. Then banks are filing with the debt recovery tribunal. There also some problems are there. So today, even though Surface, DRT, third stage IBC, if you see the most of the cases filed by the banks, already these two options are already exercised by them. The Surface as well as the DRT also exercised by them. Take for example, in a particular case, if he is argued that not given notice also, then Surface 13.2 is also you can show as an evidence for the invocation of the guarantee.
Okay.
According to NCLAT rulings, if the notice is addressed to the guarantor and the demand for payment in terms of the guarantee agreement, it acts as a formal invocation, enabling subsequent legal action. So, in that case also, you can quote this type of case study. IBC not a recovery mechanism. Multiple NCLAT orders. Creditors are filed insolvency purely for recovery ruling. Tribunals reiterate that IBC is for the resolution, not recovery. Important guiding principle is RPs for RPs and banks. So here also, even though we are talking about the COC and the COC is having power and voting rights, still in their minds, how to recover the amount in their minds. But on the paper, even though we are talking about resolution, but their agenda is how to recover the funds as early as possible. As early as possible. But this particularly, this resolution, that point to be imbibed in the minds of the bankers. Bankers are always thinking about that IBC is also like a SURFACE or debt recovery tribunal like that. IBC is not a recovery mechanism. Tribunals NCLT or NCLT and the Honorable Supreme Court also consistently reiterate that IBC is designed for resolution of the insolvency and the reorganization of the corporate debtor, not a debt collection mechanism. Using IBC to arm twist debtors into paying dues discourage. Using IBC to arm twist the debtors into paying dues discourage. This is for the financial creditors. This quotation, this sentence is for financial creditors. So some of the financial creditors, they are telling, no, if at all you have not paid, then we will file IBC, CARP. Then automatically your powers will be cancelled and the total firm in the hands of the COC and run by the resolution profession. This is an arm twist that the fear psychosis should not arise. Okay, but finally it is a resolution process. NCLT jurisdiction over regulatory bodies, securities laws conference. Stock Exchange argued SEBI framework overrides NCLT. SEBI is a regulator for capital market. They are always thinking I am superior. NCLT upheld IBC overriding effect under section 238. IBC prevailed over the other laws during the insolvency proceedings, whether it is a RERA or the SEBI or other regulators, if any. IBC prevail over the other acts. NCLT jurisdiction, regulatory bodies. Recent ruling of NCLAT have firmly rejected arguments by stock exchanges, specifically the Bombay Stock Exchange, that the SEBI regulations and the listing agreement override the IBC during the corporate insolvency proceedings. Admission cannot be refused on viability grounds. Corporate debtor argued business was viable and the CARP is unnecessary. That is not correct. Once the default is there and the default is satisfied by the adjudicating authority, then the case is to be admitted. Viability, feasibility, all these things are not comes under the purview of the judiciary authority, that is adjudicating authority. Once the debt and the default are proven, admission is mandatory. NCLT cannot evaluate commercial viability at the admission stage. At the admission stage, simply what is a default date, whether default is there or not, whether the paid or not. If the adjudicating authority satisfies, then the financial creditor given the loan and not paid by the corporate debtor, immediately if he is satisfied, can admit. But in case of operational creditor, the 8 demand notice followed by 9, and if there is no disputes about that particular operational creditor is there or not, that affidavit also the NCLTs are obtaining from the operational creditors. Admission cannot be refused on viability grounds. Based on the recent ruling, particularly following Supreme Court's clarification of insolvency, the arguments that business is viable and therefore CARP is unnecessary is not valid ground to stop admission of Section 7 of application once the debt and default are established. COC commercial wisdom protected. Unsuccessful bidders challenged resolution plan approval. Tribunal refused to interference of the COC commercial wisdom. COC reinforced the limited judicial review over the COC decisions. COC decisions. So recently, in one infrastructure CIRP, the NCLAT Chennai has a given judgment. That I will go through that one. 1 minute, sir. Sir, recently in one real estate that is in Hyderabad, the NCLAT reversed the CIR. So the loan was defaulted by the principal borrower. CIRP initiated borrower as well as corporate guarantors. COC constituted and issued the request for resolution plan also. Submission of a resolution plan by 4 applicants. And in the 4 applicants, one applicant is quoted higher amount, but COC finalized the lower amount. One applicant 240 crores, but COC finalized for 73. Next, earnest money deposit, EMD. Earnest money deposit, they have mentioned one date. After that date, 3 or 4 days, the earnest money deposited by the successful resolution applicant. So one is the prospective resolution applicant, 3 people are there. Out of 3, 1 person quoted 73, highest amount 240, next highest is around 200, like that. Next, evaluation matrix. In the evaluation matrix also, RP has given certain additional marks to this 73%, even though that marks are no relevance to that particular the resolution the applicant. And the second one, in the particular the first the corporate debtor and the corporate guarantee is also there. In the corporate debtor, one financial creditor full amount is recovered. The same financial creditor carry forward to the COC in corporate guarantor also. That is also pinpointed by the NCLAT. And without NCLT dismissed the objections. Okay. NCLT settled. So on account of this one, NCLT set aside the CIR, whatever the CIR. So the first one is 3 to 4 people, they have submitted the resolution plan. 73, 150, 200, 240. Example only, I am giving rough example. But the RP with a hidden agenda, he finalized his 73 crores. But where is the value maximization in this case? Once one party is quoted at 240, and the preamble of IBC says that maximization, where is the maximization? The second point is, once EMD date, they have fixed some 10th or 12th or whatever date is there. Then the successful resolution applicant paid after 3 days or 2 days like that. So that is also pointed out by NCLAT in that case. Third one, while preparing the evaluation matrix, so the score, the RP intention is to give higher marks to the particular 73 crores resolution applicant. And he awarded highest marks. And he is not eligible for highest marks. And in the evaluation matrix also, the NCLAT, they have verified. And the next one is the evaluation, and once 4 financial creditors are there. And in the main case, CIRP, that is corporate debt of CIRP, 1 financial creditor total amount is recovered and he has taken. Why that a person is again appointed as a COC member? And the last one, and thereby the NCLAT is dismissed. In this case, the probability of a disciplinary action may be initiated by the IBBA. Because here, highest bid, why you have not taken into consideration? 1 or 2 lakhs or 10 lakhs, other 10 crores or 20 crores, no problem. Because the commercial wisdom rested with the particular the COC. But where is the 70 crores? Where is the 240 crores? The wide variation, 170 crores difference. So the commercial wisdom shield will also not applicable in this case. Wide variation. Okay, 10 crores or 20 crores, there is no problem. Second one is unnecessarily what you have given.
Which is this case, sir? Sorry. Which is this case, sir?
This.
Sir.
How
Which is the case?
difference?
Name of the case you have, sir?
Name of the case, sir. Manjeera Constructions.
Manjeera Construction. Okay.
Hyderabad.
Thank you, sir.
Hyderabad.
Okay, sir. How is COC approved with this much variation?
That is pointed out by not me. The NCLAT is Chennai. And once you have given one deadline, once not paid on that particular deadline, again you have to come to square one, or take the permission of the COC, or take the permission of NCLT. Sir, on due date, he is unable to pay, sir. Only 2 days he is asking. And if you permit, I will take it. Then the RP is not responsible or accountable for that. So here, the second mistake, then the COC is told, no, this is finalized by RP only. He has given recommendations. Accordingly, we have finalized that particular 73 crores proposal. Third one, evaluation matrix also we have to submit to the NCLAT, to the adjudicating authority NCLT. In that case, it is not a simple the marking, even though examination also, if at all he is not writing and simply you are awarding marks, then everybody will question here also.
Correct.
In this case also, evaluation matrix, higher marks given. And the third one, the major drawback is Once debt is satisfied, debt is recovered, why you have brought that particular person in the corporate guarantee? Even the company total amount paid in the first instance only. Why you have brought in the corporate guarantor CIRP process? Then they reversed that one. In the meantime, what was happened? 1 year back, the process was completed. Today, the successful resolution paid the full amount and started the operations, and home loans are also they allotted the whatever the balance amount he recovered and allotted, and people are also occupied. Home buyers are also occupied. Now 1 year completed. How this case now both are approached the Honorable Supreme Court of India under fundamental rights. He is arguing successful. Sir, after 1 year, COC commercial wisdom. But these people are arguing commercial wisdom. There is some limitations are there. But one person is offering 70, another 240. Why you have finalized 70? So definitely, if at all any small errors are there, it is dangerous for the RPs also. Today, RP is unable to answer. RP
Sir,
is unable to answer. Sir?
Sir, one question, sir. How
Sir.
come NCLT blindly went by the commercial wisdom?
Correct, sir. Correct. For that also,
they are also at fault, no, sir?
Correct. Yeah, there also that NCLAT also told about this is some they are using the word error or some minor negligence like that they will use. Error. This is the gross negligence, not error.
Correct.
Not
correct.
Sir,
Correct,
once 240, 70, then some investigation is required.
Correct, sir. The adjudicating authority should have noticed.
140, it is not 140 rupees. It is 140 crores.
Correct.
Thereby, what was happened? Then personal guarantor to corporate debtor also started. Had the 240 is taken, the corporate guarantor, the initiation is not arised, and personal guarantor not arised, then automatically the cost is increasing. Second one is now it is a problem to reverse it also.
Sir, looks like a big collusion has happened, sir, in this case.
Now, how to reverse?
Lulu Mall case, sir, yeah, this is.
Sir, same case.
Hyderabad lo
Oh, sir. Same case. Okay.
Lulu Mall is the corporate debtor, MRHPL, Manjira Holdings Private Limited, like that. The MCL is the particularly the corporate guarantor. Now the personal guarantor means directors. Okay.
Sir, when resolution plan is implemented totally, whether personal guarantors will be relieved from their liabilities or some banks are again filing after implementation of fully resolution plan, they are invoking the personal guarantees and filing the cases before NCLT under section 95. And after implementation of the resolution plan, again these guarantees are alive to file it before NCLT.
Yes, sir. Yes, sir. Now that's why today what is happening is simultaneously they are filing both the personal guarantor to corporate debtor and the CIRP in one go.
Now they are filing, sir. It is the case of 2018. Implementation is done, and bank out of 30 crores liability, bank received only 3 crores.
57 they can recover from guarantor.
Personally, whether they have locus standi to file like that, That
Yes,
is
sir.
not-
Yes, sir. Yes, sir. Subject to whether that guarantee agreement is in live or stale.
continuing guarantee it is.
Continuous guarantee means live. Live means even that is settled 3 crores, still the bank is having a right to recover the amount from the director or the personal guarantor to corporate debtor after the completion of the CIRP also.
Okay.
So today, how to reverse that CIRP? Is there any way out? No way out. Already completed. Okay.
Supreme Court, sir.
Now,
Supreme Court can reopen, sir. They have the
uh,
Brahmastra.
no, correct. Brahmastra is there, sir, but the effect, whether they are using that Brahmastra on NCLT or the RP or the successful resolution applicant or the 240 crores who is submitted.
No, first
Only time will tell, sir.
RP only
How much?
responsible, sir. Even if you think it like that, first entry level is RP's liability will come.
Correct.
Second entry
Correct.
level liability NCLT.
The SRA is not liable and not accountable or liable.
What is his role? He has submitted his role.
Yes, the product he purchased,
Sir,
whatever option product is there, he purchased.
I have given my quote 10 rupees, sir. It is up to you to give it to me or not.
Correct.
I am SRA. My quote is 73.
Correct.
You have given me to take company.
Yes. That too 1 year back. That too 1 year back.
1 year.
Sir, practically it won't be that simple, sir. Of course, the person who has given 73 crores might have played many fraudulent acts so that the RP or NCLT, I don't know whether we can't blame NCLT and all. All those people, he must have done something so that they accepted it, right?
For 240, RP should justify before COC, na, sir. Why he will accept it?
Yeah, RP definitely would be involved. I don't think without RP's involvement, it will
RP
really
has
happen.
not evaluated properly. COC consists of so many bankers, professionals. They would have taken care of it.
Yeah, that's what. So when the Supreme Court examines, I think all this might come. Whether it has gone to Supreme Court, sir? No.
Sir, here, okay, remaining cases are very easy, but what is my opinion I have developed? Please go through this one, sir. I will stop here. I will open that one. That is a good case also.
Okay, sir.
The perception thinking, my perception thinking on that particular case.
That's very interesting case, sir, actually. From academic and professional point of view, both.
Next, final version, part 1 and part 2. Part 1 and part 2. Is it visible, sir?
Yeah, it's coming, sir. Yeah, now it is visible, sir.
Sir, I have developed this one in part 1 and part 2. Because I am not a judge and I am not a judicial authority. The following are my personal views based on IBC provisions, CIRP regulations, and judicial precedents, etc. Introduction. The case stems from the judgment delivery by the Honorable NCLAT, Chennai, on 19th March 2026, where the resolution plan submitted by Valentis Laboratory Limited, despite receiving overwhelming approval, 94.52% COC voting from the Committee of Creditors, was declared invalid and set aside. Now, the NCLT decided, no, whatever the Valentis laboratories are there, even though they got a 94.52 voting right in COC, that is invalid and set aside. The NCLT also ordered a reconsideration and other resolution plans. Dissatisfied with this decision, Messrs. Valentis has appealed to the Honorable Supreme Court, challenging the legality, jurisdiction, and practical implementations of NCLT rulings. The main issue concerns the extent to which the courts should be intervened in the commercial wisdom decisions of the COC, and whether procedure laws justify, nullify a resolution plan that has otherwise been approved and implemented. That is point one I wrote. Second one, extent of a judicial review. Even NCLAT also, the judicial review under insolvency, certain conditions are there. According to IBC, especially section 13, subsection 2, 31 and 61, judicial authority have limited power to interfere in the resolution plans. Honorable Supreme Court in the case of Seshidhar versus Indian Overseas Bank and the Committee of Creditors of SR Steel versus Satish Kumar Gupta has consistently emphasized that the commercial judgment of the COC is supreme and should not question unless the plan breaches the mandatory legal provisions. In this matter, the Valentis, who is a successful resolution applicant, argues that the NCLAT overstepped these established limits by reassessing the merits of the competing bids and replacing COC's decision with its own opinion, without identifying the clear violation of section 30, subsection 2. Issue regarding delay of earnest money deposit. A key decision for the NCLAT's intervention that a Valentis deposited created after deadline, making resolution plan non-responsive. Messrs. Valentis, however, maintains that the payment was initiated within the deadline and the delay was caused by the banker's technical issues and beyond the control. They told, I have deposited the amount, bank has credited that amount after 3 days or 4 days. It is not my fault. They are arguing like that. Legally, the Supreme Court in Kalparaj Dharmashi, Kotak Investment Advisor, has taken a practical stance, ruling that the procedural formalities, these are the procedural formalities, should not override substantive compliances, especially when no harm is caused. Thus, NCLAT strict technical interpretation of a request for resolution clause may be considered excessive and unlikely be upheld by the Supreme Court. Next, primacy of the COC commercial judgment. NCLAT criticized the COC for approving the resolution plan with 83.54 crores, which is lower bids submitted by the other applicants. However, it is well established maximizing value does not always mean choosing the highest financial offer is important. The COC is entitled to consider qualitative factors such as feasibility. Okay, I'm quoting 200 crores. Whether I'm going to pay that amount or not, that a doubt may arise to the COC also. So that's why feasibility, viability, certainty of execution. Okay, I quoted 240, but my net worth is 10 crores. How Mr. Prasad will bring a 240 that the COC may think like that. And the COC entitled to consider qualitative factors such as feasibility, viability, certainty, execution, and financial banking. Mrs. Valentis demonstrated that the plan has been bank sanctioned and offered greater certainty in implementation. Once the bank is also given approval, no, we will sanction this much amount to Valentis. So the COC confidence, okay, this is even though the amount is less, but the amount they are guaranteed to get the amount from them. The Supreme Court in Maharashtra Seamless Limited versus Padmanabha Venkatesha has clearly ruled that COC may lower bid if it is commercially more viable, and the appellate authorities should not interfere with such decisions. But here NCLAT has intervened. Therefore, NCLT intervention on this basis seems to be contradict established legal principles. Next one, interference of evaluation matrix and scoring system. NCLAT also observed that the scoring of evaluation matrix used by the resolution was arbitrary and favored Valentis. However, evaluation matrix is a part of COC commercial decision process, and the courts have consistently avoided interfering such matters. In PNC Infratech Limited versus Deepak Maini, it was held that the scoring mechanism is not subjected to judicial reviews unless it violates the statutory provisions. In this case, there was no finding that the evaluation matrix was unlawful. Hence, NCLAT reassessing the score appearing to be overreached the commercial territory. Sir, are you listening, sir? Hello?
Yes, sir. Yes, sir.
Am I audible? Am I
Yes,
audible,
sir?
sir?
Very,
Yes, you
very
are
much
audible.
clear, sir.
Validity of COC composition and participation of common creditors. So, first the main CIRP, followed by the corporate guarantor. So, in the main CIRP, the financial creditor already satisfied his debt, and that person is again joined in the second, that is corporate guarantee. The NCLAT is raised concern about the certain financial creditors. Catalyst or Fed Bank, that is financial creditors, continue to participate in COC even after their dues are largely secured through CIRP of the principal borrower. However, the law now clearly permits simultaneous CIRP proceedings against both the principal borrower and the corporate debtor, which guarantor liability being a coextensive. Recent Supreme Court ruling has clarified that creditors are not required to choose between the remedies. Additionally, Regulation 12A of CIRP frame that ensures claims are adjusted to prevent a double recovery. Therefore, NCLAT reasoned on this point seems to be more equitable than legal and may not be whole. Treatment of a dissenting and minority financial creditors. Challenging before NCLT was brought a dissenting financial creditor holding a 3.30 voting share. Next, while such a creditor has a right to raise objection, the Supreme Court consistently held a minority creditor cannot be challenged the resolution solely based on dissatisfaction. Actually, this complaint also raised by one financial creditor who is holding a 3.3% in the COC. And solely based on this, and particularly section 30 subsection 2 in India Resurgency ARC Private Limited or Amit Metallics, it was held that dissenting creditors are entitled only to the minimum statutory protections and cannot be questioned majority commercial decision. Thus, the weight given to NCLAT objections, minority creditor appear disproportionate. Next, impact of the execution of the resolution plan. A key distinguishing aspect here, the case is Mr. Valenti's resolution already approved by the NCLT under Section 31, fully executed with payments made to the creditor, but a significant progress also completed, reviving the corporate data. The Supreme Court in Abex Singapore Private Limited, COC EduComp Solutions Limited held that once the resolution is approved, it becomes binding and final and should not be disturbed lightly. Interfering at this stage would compromise the certainty and stability of the insolvency process. Therefore, the NCLT decision disrupt the already implemented plan raises a serious concern, and this is likely unfavorable in the Supreme Court. Breach of a natural justice principles. Mr. Valentis also raised the important procedural issue, noting that neither made party nor heard before the NCLT, despite being a successful resolution applicant. They have not listened. The NCLAT not listened to the successful resolution applicants' comments, directly impacted. If this claim is proven, it represents clear violation of natural justice principle, emphasize ad aeternam paritum rule, the right to be heard. Courts have consistently ruled that any order passed without hearing an affected party is liable to be overturned. This alone could justify the Supreme Court intervention of NCLT's order. Comprehensive legal evaluation, expected outcome. This is my personal views only. Considering the facts, legal provisions, and judicial precedents as a whole, it appears NCLT oversteps its authority by intruding into commercial decisions of COC, applied an excessively technical approach to procedural matters like earnest money deposit one, failed to respect the finality of the execution of the resolution plan. Conversely, the Valentis civil appeal is strongly supported by binding Supreme Court ruling and aligned with the core objectives, and which include timely resolution, maximizing value, and all this. Concluding.
It is NCLAT or NCLAT, sir? J. In the J, you have mentioned NCLAT, na, sir?
NCLAT.
NCLAT, na? There it should be NCLT, na?
No, sir. Here, final decision who has given?
NCLAT only, sir.
Okay.
Final decision, from final decision to Supreme Court. Concluding opinion on likelihood of success. Based on the above analysis, civil appeal filed by the Valentis Laboratory had a strong chance of success before Honorable Supreme Court. It is highly probable that the Supreme Court will overturn the NCLT's judgment, reinstate the resolution plan, and reaffirm the primacy of the COC's commercial judgment, along with the importance and finality of the insolvency proceeding. Part 2 also I have written, sir. This is my personal views only, based on IBC. Strong arguments from the respondent side. And that is a dissenting financial creditor. That is 3.3% percent. Supporters of NCLAT order. NCLAT supports this financial creditor only. Core strategy. The respondent's strong line of argument is, this is not a case of a mere commercial visit. It is a case of illegality, procedural violation, and breach of a CIRP framework. Probable answer, they have to. EMD delays is a fatal non-compliance, non-technicality. Argument. The respondent can strongly argue the earnest money is a mandatory eligibility condition under RERP and the CIRP framework, and non-compliance rendered to the resolution plan non-responsive. Clause 12 of request for resolution clearly mandates EMD must be submitted along with the resolution plan. And EMD credited on 12/2/2024 after the deadline of 9/2/2024. Therefore, volunteers are ineligible to threshold. Legal basis. In that particular, whatever the regulation 36B 4A of a CARP regulation, RP shall ensure the compliance of with the request for resolution plan terms. And section 25(2)H, that is clause H of IBC, RP must invite the process of plan according with the conditions. And for that, judicial support is ArcelorMittal India Private Limited, Satish Kumar. Eligibility condition must be strictly complied. NG projects versus Vinod Kumar Jain, process integrity and param. Probable answer before Supreme Court. EMD is not a procedural formality, but a substantial eligibility condition. Once the timelines are breached, the resolution applicant becomes non-responsive, and the RP has no authority to dilute the request for resolution plan without COC approval. Second point, RP has no power to relax request for resolution condition unilaterally. Argument. RP accepted delayed payment without amendment of request for resolution and approval of here for that 3 days he has not taken any approval from COC. This is ultra virus of the code. Legal base regulation 36B. Any modification requires due process. Section 208, that is subsection 2 clause A, RP must act with integrity and objectivity. That is not happened. That judicial support is also there. Swiss Ribbons Private Limited Union of India integrity is core to IBC. And Gujarat Arja Vikas, the Nigam Limited, RP must act within statutory boundaries. Probable answer, the RP cannot rewrite the rules mid-process. Allowing delayed EMD without formal modification of a request for resolution violates the transparency, fairness, and the level of a playing field. Third one, commercial wisdom is not absolute, subject to legality. Argument. So, the respondent must strongly argue commercial wisdom applies only valid plan exists. If the plan is non-compliant, process is illegal. The COC approval become the irrelevant. Legal base, section 30 subsection 2 IBC, RP must ensure the plan complies with law. Judicial support, Shashidhar versus Indian Overseas, judicial review allowed in case of illegality. SR Steels also court cannot intervene in section 30 subsection 2 violated. Probable answer from the respondent, commercial wisdom cannot sanctify the illegal plan. If eligibility conditions are breached, the plan never enters the zone of the commercial consideration. Next, point 4, level of playing violated Article 14 principles, allowing volunteers despite a delayed EMD, creates unequal treatment, discriminate against other bidders, violates fair competition principle. Judicial support also. Rama Dairam Shetty versus International Airport tenders conditions must strictly follow. Monarch Infrastructure versus Commissioner 2000, no relaxation of tender conditions post deadline. Probable answer. Other bidders are compliant strictly with the timelines. Allowing a volunteers amount to change the rules of the mid-game violates Article 14 of the principle. Next, value maximization objective is violated. Highest bid 230 crores and 271 accepted 83.5 crores. Massive haircut here without a justification. Legal principle, preamble of IBC, value maximization is the core objective. Judicial support, Swiss Ribbons, value maximization fundamental. and Rajagopal Swami, is that the Palani founder. COC must act value maximization. Probable answer preference for a drastically lower bid without proper reasoning indicates arbitrary exercise of the commercial wisdom, which is open judicial scrutiny. Next one is role of a majority of the creditors, conflict interest. Majority of the creditor already recovering amount from the principal borrower of the CIRP continued voting in guarantee of the CIRP. And the conflict of interest, distorted decision making. Section 21 IBC COC reflects genuine financial interest, judicial support. Rajagopalan case, COC must act in interest of CD. Probable answer. Once the recovery is assured elsewhere, there is incentive shift away from the maximizing value of the corporate, thereby vitiating the COC decision making. The evaluation matrix manipulation, argument, disproportionate marks awarded to volunteers. Minor difference inflated the favor to one bidder. Lack of transparency and possible legal bias, Regulation 39(3) CAR. Judicial support, Phoenix ARC versus paid financial services, fairness of COC decision making. Probable answer. When scoring anomalies are directly influence the selection of each one bidder, the process become arbitrarily and legally vulnerable. The last one, last but not the duty of the RP under Section 25 violated. Protect the interest of all the stakeholders, ensure fair process. Legal bias, 25 subsection 1 of duty to preserve the value of the seed. The RP is a neutral facilitator, not a decision maker favoring the bidder. Its failure strikes the root of the CIRP integrity. Implementation does not cure illegality. Argument. Volunteers argue plan is already implemented. Respondent must counter. Illegality cannot be validated by execution. Judicial support. State of Punjab, Devendra Pal, that illegal acts cannot be cured subsequent events. Suggested if the action is void ab initio, subsequent implementation cannot be legitimate it, otherwise illegality become irreversible. Next, natural justice and argument misleading. Volunteers claims not heard in NCLT. The respondent cannot argue. Volunteers is aware of the proceedings, could have intervened, but appeal concerns the process validity, not a private dispute. This is not a dispute inter-se parties, but matter is the public insolvency process integrity. Absence of impediment does not invalidate the illegal plan. The last one is overall respondent position of the Supreme Court. Response should be crystallized. This is not a challenging a commercial decision. This is a challenge to illegality, a challenge to procedural breach, a challenge to process manipulation. Final strategic submission, where every entry of the resolution applicant into process is illegal. All subsequent steps of the COC approval and the plan implementation stands vitiated. The Honorable NCLAT has rightly exercised the jurisdiction to preserve the sanctity of the insolvency framework. Sir, are you getting my point, what I am telling? Sir.
Yes, sir. It is very, very complex, sir. So many things are involved. But since natural justice is argument is taken, another possibility could be Supreme Court could revert it back to NCLAT for hearing the person, I think Valentis or whoever it was, and then redecide again. Possibility is there, what I feel.
Correct. That is a possibility. That is the first stage I have told like that only. But respondent side, what are the arguments to be made? That I have given some information as far as my knowledge is concerned.
Yeah, one thing I fully agree, sir. When there is a illegality, I don't know whether illegality was proved or not in this case. Of course, there are some indications as to illegality, but then that itself may not be sufficient, no, sir. Illegality needs to be proved. If there is a clear proof, then probably Supreme Court may uphold NCLAT order. Possibility is there.
Actually, in this case also, sir, that apartments are completed and handed over to the home buyers, the process is completed. But that 240 crores and 70 crores or 80 crores, whatever it is there, why the difference is there? Why the difference?
Correct. And whether the Valentis played any illegal role, that I think... Yes, normally, if there is a illegality, normally Supreme Court would always decide otherwise.
Sir.
That's what, just my thought, sir.
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 So the next week or after 2 weeks, the Supreme Court hearing will start. We will see what is happening. So the NCLAT, they have reversed that CIRP like Boston Stills. Like Boston Stills, Supreme Court has reversed the CIRP.
Correct. But they don't have that Article 142 power now, sir, in CLAT.
They are having Rule 11. Rule 11 they can use.
Okay.
Sir, PPT share.
Okay, sir.
Please share the PPT. Sir, please share the PPT. Share the PPT, sir.
Okay, sir. Okay. Sir, second one, tomorrow we will discuss about IM.
Okay, sir. Please.
Thank you very much, sir, for the excellent analysis.
Sir.
Very interesting.
Okay. Very interesting.
Sir, one more thing. Here, it is not analysis. It is an opportunity for it.
Correct. For us, definitely.
Always everybody is thinking, I'm not getting cases, and a lot of supply is more, demand is less, and influence is required, recommendations. That is separate. From corporate data side, if at all you provide services, it is a big opportunity. You provide because as per the rules, as per the code, as per the regulation, or as per the judicial precedents, if at all you provide, because here the RP is that it's some mistakes. Okay, some mistakes. That mistakes, if you highlight, then the corporate data will also satisfy. But we have to provide some services to the CD side also. That is missing in most of the places. So you start providing services as per the code only, not bypass the code regulation. This is some of the people in Hyderabad, they are providing services to the corporate data. One case, the small case, and I will discuss and I will close. One pharma company is there, pharma company. It is located at Vijayawada. Okay. It is a MSME. The corporate data is having 2 units. One unit met with a fire accident, and the second unit is running. But to get the claim for the second unit, he spent a lot of time with the insurance companies. Thereby, the first unit is suffered a liquidity problem or other problems. The Punjab National Bank, they have financed to the company. Once the company is a liquidity problem is there, they suffered and immediately they filed the case with the NCLT Hyderabad. Amravati, not Hyderabad, Amravati. Then process started. And huge amount of expenditure is incurred. And the particularly resolution professional, he is charging at that time 4 lakhs per month. And every time he is stopping the activity, he is coming to Hyderabad and attended for the COC meetings. And he approached me. Honestly speaking, he approached me. Then I wrote a letter directly to the managing director of the Punjab National Bank. Sir, this is a small unit. The default is also on account of that particular second unit met with the fire accident. His time and focus are giving attention on the second unit only. That's why this liquidity problem arises. But however, he is getting this type of orders, export orders for the parachute mall and other medicines. In the coming days, PPIRP is also eligible. Why can't you consider under PPIRP? Then next, a small parrot. If at all you are using Brahmastra, then automatically it will die, sir. For Indian economy, MSMEs play a vital role and backbone to the economy. If at all these units are killing like that, unemployment will increase and GDP growth will decrease and a lot of problems to the economy. Government will also not get a revenue. All these things I highlighted in that letter and I directly shoot that letter to the managing director. Immediately, managing director called that particular general manager of that stress resource department. First, you go there and withdraw that case. So, and then before that, this borrower is not talked by the great officer or the divisional manager. No, don't come to the branch. Don't come to the branch. Your case is already filed with NCLT. If at all it is there, you tell to the adjudicating authority. And on that day, whether you believe it or not, 10 calls received. One is from the general manager, deputy general manager, assistant general manager, divisional manager, and the credit officer. Where you are, sir? Please come. And we have to take some letters from you and we want to withdraw them. So here, some genuine cases, if at all you are provide service, the knowledge support, then automatically they will be benefited. We will also be benefited with a reasonable remuneration. So that's why I told all these things I displayed. This is not exaggeration and other things. Because opportunities are available in the market for any profession. We have to search, we have to scout, we have to scan, and we have to use the opportunities in a proper manner. Then the professional, whatever the knowledge is there, we have to share to others also. So try for other avenues. Anyhow, I'm going to discuss about PPIRP. On account of this war, lot of opportunities are there for the PPIRP. And how to prepare the base resolution plan, most of the people are not aware. That also in due course I will discuss. And thank you very much and patience listening from 2:30 onwards. And tomorrow we will meet, sir.
Thank you, sir. It was very, very, very interesting, sir. Thanks for the nice. Sir, just one comment. The RP in the Valentis, the case, whatever the case you just examined elaborately, there is also possibility RP could have even examined all these points and made a detailed note.
Why he chose 73 crores. Valentis definitely they may win in the Supreme Court, but a disciplinary action definitely will be there. That IBPA side definitely
it could be there because of NCLAT order. But if RP had clearly articulated and written down the reason, because practically just we can't go by the number, no, sir, 240 crore, you only explained 240 and 73. Obviously, 240 is better, but then what is there inside, we don't know, correct?
Second one, sir, here 240 crores persons or 270 crores persons also, they have submitted their net worth statements also.
Okay. Yeah, that's
And
what.
along with the net worth statement, that Xerox copy of the properties also enclosed.
Yeah, if RP has colluded with somebody and done something, obviously he has to be punished. But
Yes.
if he has valid reason and if there is a real lacuna in the highest bidder and he has
Definitely, sir.
clearly written down, then probably he can escape. No, sir, he can come out without any.
Sir, definitely in this case, IBBA will initiate the specific audit also. Specific audit.
Correct. It appears too complex.
Random audit and specific audit is there. Na? So out of these two, specific audit they will initiate and they will take some action. Okay, sir. Good night to all.
Yeah, thank you, sir. Thank you very much.
I have a small question if time permits to answer. Very small.
Tell me, madam.
Okay. If you're aware of any such case wherein the Section 7 application has been filed by a CCD holder, a compulsory convertible debenture holder, because I've seen there are different case laws where somewhere NCLT says CCDs, though they are compulsory convertible into equity shares, but in some cases the NCLT has taken a view that until converted, it will be treated as debt. However, somewhere I have seen the consideration that how they will treat it is it's equity capital in a way, because FEMA also treats as equity instrument, so it is at par with the equity shareholders only, because the intent was not to repay but to have a long-term investment as equity share.
Correct.
So what is the final, right now, what's the final?
Yes, madam, to my knowledge is concerned, debentures are two types. One is convertible debentures and second one is non-convertible debentures. Convertible debentures on maturity date, whether it is fully convertible or partially convertible, till such a time, particularly the shares or the debentures are to be treated as a debt, not equity. Once it is converted, then only it is to be treated as equity. Till such time, it is to be deemed to be treated as a debt. That's why we are appointing the particularly authorized representatives for the class of creditors. Debentures comes under class of creditors, like home buyers or debentures or bonds. To my knowledge is concerned, 100% the convertible debentures are also to be treated as a financial debt up to maturity date. After maturity date only, that is whether the company is going to convert fully or partly, that is a different. Till such time it is a debt. And so the time value of money is there. And every quarter or half yearly or yearly, the interest is also to be paid to the debenture holders by the company.
Usually, yeah, it is payable, but usually the usual terms of such CCD agreement is that any interest that will accrue on this debenture will also get converted into shares, which we have seen in practically what's happening in the corporate world. And usually CCD agreements are drafted in a way that they have a clause that in case of liquidity, a liquidity event is defined as CIRP, world liquidation, and many more such events are defined there as liquidity event. Once it triggers, they will get automatically converted into equity shares. Now, sometimes it may happen that while filing the application, though the NCLT treated is considered as a financial debt and admitted the petition also. But once it is admitted, and since the liquidity event has triggered, probably RP might have to convert it into equity shares, and then they might come at par with the equity holders, after admission of the application. So I think there could be a case where for the purpose of admission, they can be CCD holder, but when liquidation will happen eventually and whatever mechanism will be there, they might stand at par with the equity holders, because by that time they will get converted. So their treatment at the time of admission and at the time of payment could be different,
Correct. But at the time of admission, now only we will see. Later on, that is a different.
Understood. Okay, thank you so much for your views on this.
Okay.